Right, I finished The Trial Lawyers by Couric, Emily Couric, copyrighted in 1988. It covers about 10 lawyers. There's diversity. It's mostly white lawyers, famous white lawyers who are successful with certain big national media attention type cases. Mostly like eight white guys, one lady, and one black guy. So they try to give some diversity with like the history a little bit and future technology being used for the late 80s. A lot of good points in here. Not the best reading. It's a put-down kind of book. There's parts that you just don't get enthralled with. But you learn. If you push through it, you learn. So, starting off on like these are points that I found interesting in the book. On page 7, defendants must decide what will be their own theory that is consistent. If you argue 10 points, even if each is a good point, the jury won't remember them all. Keeping your defense simple, even keeping your prosecution simple, whichever side you're on. When you're working with a jury, you want to keep pounding in that perfect theory, that theme of innocence or guilt, and not try to bring up every argument. On page 10, selecting witnesses is almost like a beauty contest. The lawyers want them to be likable, nice, sometimes a little overweight, decent, straightforward, and modest. So jury selection is a big decider for whether you win a case or not. You have to do a lot of work outside of the trial to affect a win. On page 17, the witness needs to be prepared by the lawyer before taking the stand. If the witness gives a silly answer, then the lawyer needs to reduce them to a ball of jelly. Needs to grill that witness to make sure that they don't give silly answers on the stands. The witness has to come out of that during the trial. The witness has to come out of the cross-examination thinking their lawyer was tougher on them than their cross-examiner during the trial. On page 25, jury people pick up on the little things. One lawyer was claimed not to be interested in their trial because they didn't take notes in the courtroom. So one jury member thought that the lawyer was not interested because he just didn't take notes. So he started taking notes. On page 41, anything between the knees and waist, come to me. This is the lady lawyer who talked about her specialty, which is sex crimes, and that's how she described her work. On page 44, some of the most difficult rape cases to prosecute are against established professionals. And this is the case. This is Gloria Ronstein. Linda Fairstein. She had to prosecute a dentist who was sexually feeling up ladies who are under the influence of his drugs when he'd knock them out for tooth repair. So it's interesting that they say that some bum on the street would be easier to prosecute for sexual problems, but a professional can. Well, let's see. All right. Well, I'll move on. I'm just saying there's a difference. Professionals, people take that as it's more of a surprise that they would do something sexually wrong to another person. 47. When prosecutor has cause to believe, they can get the judge to plant hidden video cameras in your office. They planted hidden video cameras in the dentist's office because they couldn't prove that this professional was like sexually using women, pretty women. They couldn't prove it. They just, everything they tried, but they still believed he was doing something wrong. So they planted video cameras in his office. The judge allowed it. Just simply because the prosecutor had cause to believe. Cause to believe. That might be a legal term. At 49, she rationalized that professionals handle confrontation better than street thugs, so hidden cameras were more needed. So, with the professional may be able to talk themselves out of sticky situations easier, but that doesn't mean that they get less. That doesn't mean they get the same amount of scrutiny. This dentist got more scrutiny by being able to talk himself out of a lot of the controversy over using the drugs. He said he had to do some procedures to help revive the pretty women after he did dental work for them, which involved him grabbing their butts and waist and breasts and all over and standing them up and whatever. He was doing all kinds of stuff. They used a pretty undercover lady, and then recorded that. On page 52, women lawyers in the courtroom challenges male lawyers' gallantry. So the males can't be the heroes so much. They have to work on appearing more equal between the sexes. On page 56, the University of Colorado study showed that attractive, well-dressed, clean-cut men get acquitted more than the unattractive, dirty-cut, poorly dressed men. So you get off easier when you look attractive, and they say that study came out of University of Colorado. On page 76, this is from Linda Feinstein. I always feel that I don't want to take the chance of leaving that one thing out. And that she's the rarity out of all these. She was like successful, so she was interviewed. And she was a woman too, and he had to bring a woman into this book, especially with a woman author. All the other guys kept their cases simple. They didn't want to worry about leaving something out. They just wanted to keep the theme, keep everything simple, break things apart. But Feinstein just had to tear into everything. And that works for her. That's her style. On page 96, in the DeLorean case, and DeLorean is a car, DeLorean is the guy who made it. The Ninth Circuit Court ruled in favor of the established power media because they wanted to quash this undercover videotape of DeLorean saying cocaine is the new gold, and they wanted to keep that down because that would influence any potential jury members, because the government was trying DeLorean for cocaine, for sales or for financing the sale of cocaine. He needed to make some money because his DeLorean business was failing. Apparently today you can still have a custom-made DeLorean made from some company. But I think DeLorean eventually went bankrupt at some point in the 70s or 80s. On 102, in defending DeLorean, Weitzman characterized the FBI agents as play acting, and the only one who did not know they had the part to play was DeLorean. So the FBI agents were just stringing him along, and that's like they didn't say entrapment. It was like before entrapment. I wasn't quite entrapment because he didn't actually finance anything. He didn't finance but he joked around with them about it. And when he said, cocaine is a new gold. Actually, I think he said something else. It was something like that. The way the FBI agents reported it was like, he was serious about that. He's trying to get into this business. But he was actually on tape joking about that, and even an FBI agent laughed. But, the way the FBI agent reported it is he used his words against them, but not in the context that they were being used until the tapes were played. On 107, the skill of the entrepreneur is to change the roles so that the person with the money is real thankful that the entrepreneur is giving him the opportunity. So, yeah, the skill of the entrepreneur, they want to just make you feel thankful that they came to you to give you this opportunity. On 111, the lawyer's questions have to be phrased in such a way that the response is not only what the lawyers want, but one that tells a story to the judge. And I'll say this later. I'll just say it now, that a lawyer doesn't ask a question they don't know the answer to. They don't like working like that. On page 119, traditionally, juries are not interested in giving anything unless there is a visible, permanent injury. So, like with me, I wanted to maybe sue a cop for violating my rights, but he never hurt me in any way, physically. So the chances of really getting a decent jury verdict is pretty small. On page 122, Harney uses a formula to decide whether to take a case based on merit, financial potential, and jury appeal. It needs to have this soup of appeal, and that's how Harney is an attorney. On 124, Harney has doctor clients whom he doesn't charge, and the reason for that is barter. They can turn around and give him some service later, so he just doesn't charge doctor friends. On 125, Harney has a record of 50-50, and then he say that plaintiffs tend to only win 50% of their cases. The other lawyers really didn't give their records because that could be used against them in the newspaper for their next trial. On 126, putting a cap of $250,000 for medical malpractice is unconstitutional. They ruled that that's just not high enough because it's just arbitrary. And this is for the guy that had a kidney removed, the wrong kidney removed, and he's suffering and sued for that. It sounds like he lived another 10 years after this wrongful surgery. But yeah, it didn't give me much confidence in doctors, how they choose their doctors and then how they conduct themselves for some real serious surgeries. On page 132, lawyers choose to act outrage if they think it appeals to the jury. Lawyers really put on a show. They put on a show, but later they say that they are more the directors, and the actors are the clients. On page 145, Harney said he was being attacked by the defense because they had no defense. So if you don't really have a good defense, just attack the character of the other person. That may be a good sign that you're doing a good job. On page 159, simplify the theory of your case. That's the theory of the book is except for the Linda Feinstein, simplifying the case is like a big theme here. On page 161, jurors' expectations were different in the 1920s, where they expected flowery speeches. That doesn't work in the 1980s. I don't know how it works in the 2010s, almost the 2020s. This is before the CSI effect. I don't know how it exactly works today. I'm getting kind of a historical perspective of lawyering here. I'm sure there's a lot of things that haven't changed. On page 168, cross-examination requires powerful listening and concentration skills. When I had my court case over a parking ticket, I could only ask questions based on the testimony of the cop and the park manager, and also the other park manager, the guy who was in charge, the park supervisor manager. And I was not finding that to be easy. I had three guys testify, all in a row, and then I had to listen to each one what they had to say, and then ask questions based on that. And that complicated things. And they set it up purposely to be like that, to make it as complicated as they could. Instead of one person testify, have three all at once. Instead of the cop testify, then I ask him questions, stop, move on to the park manager. He testifies, and I ask him questions. That would work a lot easier. But, that these kangaroo courts in Coos County, Oregon are awful. On page 168, cross-examination, 172, using anti-Semitic statements against someone by acting offended. And I found that interesting. The defense lawyer felt that somebody on the stand said something anti-Semitic. It's like, he said something like, yeah, we celebrate Christmas here. And that was anti-Semitic, because he said it in a way that sounded anti-Semitic. And so the lawyer just stood there for 20 seconds to give effect to the jury. It was acting for the jury. On page 190, many wins can come from the opponent's mistakes. So it's not always you scoring the goals. A lot of times you can get ahead just by the other side making too many mistakes. On page 197, Neal's least favorite attack is on testimony. How long were you coached? But if you have a strong defense, destroy anything attacking it. So, yeah, asking about the coaching going on with the witness. Were you coached by your lawyer? That's an argument that they could delve into. On page 201, agreeing that several doctors would say the same thing instead of bringing them all in has less impact on the jury. So this was a case where a kid rode his bicycle over railroad tracks and crashed. The wheel came off, and he crashed and got brain damage for the rest of his life. And they sued the railroad company for having for not being safe. And they sued the bicycle company because the locking mechanism for the tire was not in good shape or something. And this lawyer won the case, because he kept dangling punitive damages over the other people, and he won a lot of motions, and one of them was just not bring in several doctors, only allow one doctor, just saying, all the other doctors are just going to repeat what he says. And he felt that was a good move, because actually what may appeal more to the jury was to have several doctors keep repeating what the first doctor said, just to affirm that this is what happened. This is damage that the kid took. On page 205, everybody hates a rapist. You don't have to go out and get a survey about rapists. All right, so that's a slam dunk case right there. On 233, don't overplay sympathy. It's easy to make a jury cry, but they will be resentful of you doing that to them. On page 235, you don't want jury members to identify with opposing experts. If the opposing expert has an accent the same as a potential jury member, you don't want that jury member. If they have a toupee, you don't want the jury member with a toupee listening to the other side if they have a toupee. Anything that they can relate to, this lawyer didn't like. On page 237, you got to be street smart. On 239, learn every detail of the jurors. And yeah, that's the toupee thing and just how they dress and act and things they say, where they came from, just everything. Anything's a potential to help you decide on which juror to keep. On page 240, airline pilots make terrible jurors because they're so punctual about everything. On page 242, Corboy, this is the lawyer, writes his opening statement after jury selection. And he learned to do this because on one case, a judge restricted the final argument to 5 minutes for each day the trial lasted. So if it was a 14-day trial they had, they would limit to 5 minutes. 5 times 14, 70 or something? It's 70 minutes of that's for closing testimony. Okay, because it's hard to tell exactly how long that'll last. But this inspired Corboy to keep his opening statements to a minimum. He used to say a lot of filler statements, and he cut those out. On page 248, Corboy had defense scared about punitive damages, and the defense didn't argue small details because of it. Yeah, that's like using the multiple doctors. I can't quite remember everything else. On page 267, Chambers would argue racial... Okay, this is another lawyer. Chambers would argue racial issues to judges sensitive of it. This is the black lawyer who would argue... I think he spent his whole life arguing for civil rights for black people, particularly for desegregating schools. Actually in a lot of cases, shipping black kids further, longer distances, just to get intermixed with the white schools. On page 269, a black lawyer prefers to be called black rather than nigra. So there was the opposing side who was referring to black people as nigra, and this black lawyer, he didn't make a loud scene about it. He said he wrote it on a note and just kind of slipped it to the other side to read, saying that my client prefers to be called black. So blacks prefer to be called blacks. 272. The history of past cases in a given area often reveal community values that continue to influence court decisions. So looking into the history of how cases were ruled gives you a great idea of potential future cases. And a lot of cultures can be different from one city to the next. It's quite amazing how that works. 289. He could see discrimination under every flat rock. Sometimes they reveal horrible discrimination salamanders. So this is about the black lawyer who just his whole, it sounds like he spent his whole life just taking discrimination lawsuits to court. On page 293, finding an expert can extend well beyond the local area. So sometimes you can't find an expert in your city. You look in it could one you may have to get one 500 miles away or something. And that was kind of a concern for I think the jury, thinking this is some outsider expert coming from such a long distance away to testify. Classism is replacing racism. So this black lawyer fights racism, but now it's turned out a lot into classism. Who's got the money? And that tends to be whites in a lot of ways. 294. This judge made an unpopular decision about school desegregation. He got ostracized. Nobody would play golf with him. He needed a guard at his house. People did not like that the measure he took to desegregate schools, shipping white kids to black schools, shipping black kids to white schools over long distances in a lot of cases. And it was a very unpopular decision. This 298, the Smith and Wesson divorce. Someone pulls a trigger and the marriage is over. Kind of like with that recent one where the guy choked his wife to death and his kids too. Chris, whatever his last name is. On page 303, law enforcement take liberties with the law in their zeal to make a case. They certainly do. They'll stretch the law, whatever it takes, just to make their case. And this, a lot of it's not going to hold up in courts when they stretch it too much. 30 years ago, only a few hands out of 50 would be crime victims. Now it's a dozen or more. So he'd ask a group potential jury members how many have been crime victims, and very few 30 years ago, from 86, 76, 66 in the 50s, the crime was a lot lower. There's less property though too. We got more toys these days that are the potential to be stolen. So it's hard to tell if people are getting more greedy or if it's just there's more opportunities to steal. 314, lawyer brought computer to courtroom. He got an Apple II Plus with Visidex software. They used a high-speed tape recorder to replay testimony. Every time a cop on the stand told a bit of a lie about what happened during the undercover operation, they'd just go back on the tape and say, "Oh, this is what you actually said," and that influenced the jury to win the case. On 318, words influence a question. So instead of asking how fast was the car going, ask what was the speed at which the car was going. So if you ask how fast, that's going to influence kind of like sounding like you're going faster than you should, instead of asking at what speed. On 321, lawyers sometimes avoid a swearing match when they feel the other side didn't put on a good case. So you don't have to put on a big tantrum of testimony and stuff. If the other side loses, if they make mistakes, too many mistakes, you just kind of let their case fall on itself. On 335, cutting deals with the government does influence testimony, and that takes some real good research to learn what was the original testimony compared to the change. On page 336, lawyers don't want to steal the show. They are the directors, not the leading actors. I don't ask questions. Oh yeah, that's another statement. I don't ask questions what I don't know the answer to. I said that before. So there's a lot of great points in here. It's just, it can kind of put you to sleep, but they give you a good idea of what's going on in the courtroom. And